What's going on, everybody? This is Vinny Maletti with Maletti Law, the strongest name in law. And I just wanted to take a moment to have a quick video with everybody here because I think this is helpful for all the clients. So I also think this is helpful just the public in general. So what's the situation, right? The situation is a lot of times, you believe you have a great case. The law looks like it's really on your side. Everything looks favorable. You file your motions, you file your complaint. Everything lines up. Your arguments all seem to be supported by, your appellate division in whatever, department you are. If you're in Brooklyn, the second department. If you're in New York, the first department. Everything seems lined up. Everything seems great. You file your paper. You make your argument in front of the judge. You do a great job arguing in front of a judge. You wait for your verdict. 60 days, 120 days, sometimes unbelievably quick. And, in my opinion, in my experience, whenever you get a verdict that's like in a couple of days, it's almost typically appealable. I feel like 90% of the time is wrong. So, but yeah. So a lot of times, you think you have this great position, probably do, and sometimes you have a poor position, but great argument, great story, great background, lots of equity, lots of fairness to argue over. So, you make a case. Comes in, boom, adverse verdict. Judge rules against you. Sometimes it's completely off base, and his name will pop up when I say it. It could be a Judge Ruckelsman case where the law is just through the roof out of nowhere, because I feel in his older age, I think retirement is necessary for him at this point. Sorry if you're a supporter of him or if you're his clerk, which you moved on to better things. Congratulations. But, a lot of times I think his rulings are just bonkers lately. I have no problem with it, but I just think his rulings are bonkers. But anywho, so a lot of times, how did that happen? But I have the law. These cases say this, cases say that. A couple things I want to highlight. Number one, right? The law is the law is the law. And you can argue any way, which shape or form. There's always a case to support what you have. A lot of times there is, even if there's a case that the law might not be supportive, there's something in that case that is supportive. So, for instance, if there's a certain rule that this case espouses that kind of knocks you out, but there's an exception to the rule, you fight that exception, right? So, in my experience, there is, much like the slogan goes, right? There's a seat for every ass. Well, there's a case for every story. So, and there's a case for every argument. So I don't think, that's one thing, right? So I think you can argue either way with stuff, but, you got to take into consideration a lot of times, the judge that you're going in front of. Sometimes, sometimes it's difficult to understand the adverse verdict. Sometimes it's difficult to see where the rationale comes from. I mean, sometimes, in the case of Ruckelsman, they just might not even pay attention to whole pieces of the fact pattern. They may completely eliminate and ignore a contract, or they may completely eliminate and ignore a real critical piece. That's what my boy does. But there are other instances where you might not understand the logic. It might be like broad in your face. How they get there. It doesn't help to say it's fraudulent. It doesn't help to say that it's biased. It doesn't help that, because you can't go into this system thinking that everything around you is biased, because then what's the point of law, right? We at least have to show, you at least have to show that the law is, consistent and accurate, and that everything makes sense. You can't just go in there and say that it's biased. If that's the case, then just take a gun and take the law in your own hands, right? So, that's not practical. So the purpose of this is just to help you understand, what happens in these situations. You always get your motion to re-argue. A lot of times the motion to re-argue might not, I can't imagine it being too successful. Because you are, essentially the whole idea of a motion to re-argue is simply that they screwed up. Let me explain to you why you screwed up. So I feel like that already is a blow into somebody's pride and ego, which, if you've watched my videos in the past, it's probably 70% of your argument is appealing to someone's pride and ego and emotion. So it's too simplistic to say that because then it kind of breaks down the whole system under you. So we just kind of got to look back and think about how like judges get there, right? So think about the excuse me. Think about the interpretive analysis that they use, right? Think about how they got to where they got to. There's a couple of them. I wrote a few down while I was talking, while I was kind of making up this outline a little bit for myself. I wrote a few down. Judges use a variety of tools, at least in my experience and what I've noticed. The easiest, most simplistic one to argue when something's going to be like turned over is going to be what's known as an argument ad absurdum. So, for the first point, we'll have like an argument ad absurdum. For the first point, right? Let me just write one argument absurdum. This way I can just keep my numbers accurate. So usually you get so the first way typically to overturn something or to give you just a real weird verdict, a real weird decision is what's known as an argument ad absurdum. This is where the judge will typically take your position and just bring it to the level of absurdity. So for instance, the argument the theory of law will say something like, well, discrimination can't exist if it's, one scarce issue. And then, we could say, as in this case here, only one comment was made in September. Obviously, and more comments could have been made, but they will highlight that only one comment was made. And then they will say that it would be absurd to apply this rule to extend it to just simply one comment, even though it was multiple, but to extend it to one comment, So one of the tools they'll get there is argument absurdum if they want to kind of render a verdict that you might not really be appreciative of. Another argument I have taken down is textualism. So this kind of textualist, where they just simply strict to the letter of the law, or whatever the rule of the agency guideline that they're citing to. You see this a lot with cases involving collective bargaining agreements or with unions, where a company might complain to a union member that they're causing a strike when they're not supposed to be by virtue of their acts, but the union will come back, the member will come back and say, well, this guideline says I'm only supposed to drive this truck at 1 mile an hour, so therefore I drove it all day at 1 mile an hour. Technically, he's right. That's a textualist position. They're not looking for they're not kind of looking for the equities. They're not looking for, they're not looking for anything beyond that. It's a textualist position, and that's the interpretive analysis. If a judge happens to be a textualist, they might just be into that. So that might be where ruling goes. A third argument. I'm going to call this third argument purpose. Judges might look to the text and might see the purpose of the text or the purpose of the provision or the purpose of the rule or the purpose of the law. And based on the purpose of what that text is trying to achieve, the judge will kind of pencil it in and say, okay, well, this is what needed to happen or that what needed to happen. So purpose is a third token point that a judge may use to render a verdict that you might not like or might be a little, it could be, well, the contract didn't say that. Yeah, but we know what the purpose of the contract was. The purpose of the contract was to, sell posters. And, if that was truly the purpose, then, it should have been expected XYZ, So that could have also been another one of the reasons. Obviously, a big one, this probably should have been the first one I mentioned, but obviously a big one is precedent, right? I mean, that's supposed to be the ideal. Judicial precedent is supposed to be the ideal, but, keep in mind that a lot of times, as someone who does employment law, civil rights, and stuff like this, precedent might not be the greatest all the time. Precedent might be contrary to, cultures change over time. I like to tell people when they were fighting me with the nurses, I always would come back and say, you guys insult me for taking the position against the vaccine and whatnot. And, you guys say I'm anti-science, I'm a flat earther, which I'm not. But, anti-science and blah, 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 blah. And, you disparage me. And what's interesting is you needed people like me, 200 years ago when, you guys were 2/3, when you guys were 3/5 of a person. and not one full person, right? You needed people like me, people that go against the grain. Sometimes culture changes, whatever the case is. So precedent might not be the greatest sometimes, but a lot of times judges will, if you get a bad verdict, look at the court precedent. Precedent might have guided you. The precedent might have, they might have had a case that had similar facts or whatever the case is. So precedent might have guided you. So precedent is also another way that courts rule on things. The fifth, which I hate to talk about, I hate to talk about this because it's so subjective, but there is some judges are more in tune with the morality of the law as opposed to anything else. Some are, some aren't. Morality is kind of like, the antagonist, the textualist, right? So a lot of times a judge might make this render a ruling based on a morality of something. I mean, they won't highlight it as they won't highlight it as his level of morality, but you will see it in the language that they speak when they write their opinion. You will see in the language they speak that sometimes like they might be frustrated with something. I don't know. Let's say there's a breach of contract and somebody's an OnlyFans account and just got a breach of contract on that. There may be a judge that's not interested. So who's not interested in ruling on it or, supporting anything. So that's possible. But, moral reasoning might be another one that's here. Going through my notes again. All right. So I don't know how to say this one. I want to say, hold on a second. It could either be, I'm struggling with it, could either be sort of a structural or systemic argument. So let's just say a systemic approach. It could be a systemic approach. So number 6 will be the systemic approach of interpretation. So in this instance, when the judge is interpreting, the rule, the facts, whatever the case is, he or she might look at it more within the context of a certain system of how it's supposed to run. Perhaps you see this administrative agency. The case law says something, the agency says another thing. Judge might go, look, listen, it's within this system. This is the applicable rule. This is the applicable standard. What's supposed to happen? So we follow it that way. So that's a challenge because a lot of times that catches you off guard. And I'll make another video about understanding like the structure of government, the structure of governance and how it works. I'll make another video of it, and that's a big thing lately that's happening, and you see this a lot in New York has a big problem with that because in New York you have the city and you have the state, and they don't necessarily play well together. And what I just learned even last week, there are certain city agencies that don't answer to other agencies because in the point in time in which they were created, the powers or the scope of which their powers were addressed to touch upon, and that kind of like falls within like this systemic practice because the system determines a certain outcome, it expects a certain outcome, and a judge might say, okay, I'm not going to look at the precedent, right? I'm not going to look at whatever. I'm solely going to stick to this systemic review. So that's a challenge. That's something else that catches you off guard a lot. So and in that instance, again, you'll get a bad verdict and a completely unexpected verdict. It will be unexpected, likely to your lawyer too. It's up to me. Someone who's if the particular attorney you're retaining doesn't have experience with that particular that systemic environment, that's something that will catch you. And I've had this recently. It hasn't been in litigation, but it caught me off guard in a discussion I had, and I had to kind of like go back and like learn the whole thing again. So whatever it is. All right. So now the final part, and this is probably something that's just going to drive you. This is probably something that's going to drive everybody crazy. It drives me crazy routinely, and I almost feel like it is. I feel like it comes. It might be like a subset of morality, but I don't know how necessarily to couch it. But a judge will latch on to certain things. There are just certain things that a judge will latch on to. There are certain things a judge will just ignore. I don't know if that comes from, the lack of reading a document or the judge, a good judge will explain their reasoning thoroughly, and take the time to explain their reasoning thoroughly. So when I will tell you that when all of you want your verdicts in 1 week, that's, to me, that's the most disgusting verdict, is a quick verdict, because that is a verdict that was not thought of, it was not reviewed, it was not analyzed, it was not, there was no peer review. It didn't go to, an entry level and then a manager, then a manager. Like, it was something that was just shot off at the hip, likely missed some big things, and all that does is buy another 2 years of litigation. And, clients don't want to pay for it. You see this in the business, clients don't want to pay for it, but at the same time, their ego is shot themselves, so they want to fight over it, and it just prolongs like the whole process, and it's a big issue. So we'll just say this is, let's say this is selective omission. We'll just say, right? We'll call that selective omission or whatever. Selective focus will be more PC. Selective focus. Okay. So let's just quickly review how we look at things, how we analyze a judge's decision-making process. They could have approached it with this argument absurdum. Which is the first point, they could have approached it through this textualist concept where they just look at the four corners of the document, or they look at some broad base and that's just what they drive to. The third item is they could have looked at the purpose of the particular document or a particular statute, a particular law, whatever the case is. What was the purpose of this, what we're looking at? What was the purpose of the relationship? And this is how we're going to rule. Precedent, what's known as stare decisis. That's the fourth category is precedent. Precedent is important. Unfortunately, it's not always followed, but you know what? It should not be always followed sometimes, because times change, culture change, and there needs to be some kind of rationale between it. And the law should somewhat accurately reflect, right, the culture, at least a little bit. You can't always be this kind of like originalist, staunch, again, because, the most clearest example of originalism is being 3/5 of a human. Not proper, right? So I think that's a big problem. But whatever, that's the fourth category. Fifth, equally as bad, pendulum on the other side, is the morality, is more kind of like this moral reasoning, this moral approach to whatever you're doing. That's a challenge because it's subjective, right? No morals aren't the same everywhere. And though you like to think you have the standard moral base, you really don't. That's number 5. Number 6 is a judge might look at it in sort of a systemic, structural kind of fashion. How would this work in that system? And again, all these have their problems. In that one, you could clearly see where the problem might be, that when you don't have the expectation, right? Law is about being able to anticipate, expect, and that's how you run governance, right? Proper governance is governance that's already out there that everybody knows what to expect, and you agree within the social construct to follow these laws to have a cohesive unit. When you have like these systemic things, people might not know anything about them, might not be familiar with it, or whatever the case is, so that in itself might run into some issues, but that's the 6th category. And then the final category is kind of like the selective focus, where the judge might latch on to something and just drive that one point, or the judge might omit something and drive that one point. And that's a big problem too. All of these realistically are all big problems, right? Depending on the side of the V. If you're the plaintiff, it might not be a problem, but if you're a defendant, it might be a problem. On the flip side, if you're a defendant, it might not be a problem, but if you're a plaintiff, it might be a problem. It might be a problem, right? So it also flips on the side of the coin, which one's which. I just would tell you, a lot of times verdicts aren't what you think they are. The law could be the law, except in this instance, a lot of times, particularly in this culture, we find that the exception becomes the rule, and it's obviously not the greatest, but a lot of times this is what happens. That's not always the worst outcome, because a lot of times culture changes, regulations and rules and environments and situations change. So perhaps the exception should be the rule, right? Again, 3/5 of a person. Perhaps, that's a rule that needs to be changed. So, it varies really on what the context is. But, in all situations, you need to take rulings with a grain of salt. You need to take what was dealt and given to you as a result, and then you move forward based on that. You know, in every situation, when there's a ruling to be made, there's a winner and there is a loser. Okay? And in every situation that a judge rules on something, somebody's right has been taken away, or somebody has been harmed or aggrieved. It is an inevitable fact of life that whenever there's a rule, a law, or any kind of decision-making process, somebody wins, somebody loses. It could be 100% win and a 0% law and 0% to be a loser. It could be 51-49. It could be 70-30. It could be any number you want it could be. Someone always prevails, someone always fails. And that's how it is. It's a fact of life. If life was easy and predictable, you wouldn't have nothing to look forward to. So hopefully, at least this helped a little bit to understand the thought process. I've identified 7. I'm sure there are some scholars out there that could identify 7D. I'm sure there are more out there to look to. So I can only tell you from my experience. But, word to the wise, lessons learned here. Lessons learned in this case. If you are on the receiving end of an adverse verdict, you need to take a step back. You need to think about the decision, okay? You need to think about, go over your case, think about it, understand what the adverse decision is and its implications, understand where it came from and why, and then at that point, you'd start building your responsive strategies, right? So perhaps an appeal is necessary, a motion to re-argue is necessary, a motion to renew. I don't know. There are a wide range of responsive strategies you can enter into. Perhaps mediation is proper, and some kind of alternative dispute resolution might be proper. Think about what you gathered from the court's analysis, if it's anything to be learned or if it's just all nonsense. It could be, right? You apply those in your life, and then you just wrap it up with your strategy going forward. Always have a strategy, never have nothing. Always move forward. Sometimes 2 steps forward, 3 steps back. It happens. What's that Paul Abdul song, right? 2 steps forward, 3 steps back. And that's how it is. So, hopefully this was helpful. Hopefully this provides a little insight, and hopefully you don't get bad verdicts, but it happens to all of us. I always tell people I have been involved in over probably by now over 1,200 cases. I used to say 1,180, probably legitimately over 1,200 cases at this point. You win or lose. I don't know what my record is, but at 1,200 cases, I'm not even following anymore. So, all right. Hopefully this is well. Yours in law, love and lifts. Have a beautiful day.